Case 34, Sturgeon versus Condor Flugdienst GmbH. As you can tell, this court case takes place in the Court of Justice of the European Union, more specifically in the Fourth Chamber. Facts. This case involves two different proceedings, Mr. Sturgeon and his family, and Mr. Bach and Miss Leppershitz. The Sturgeons booked return tickets with Condor from Frankfurt to Toronto. The return flight from Toronto to Frankfurt was due to depart at 16:20 on 9th July 2005. Following check-in, passengers on that flight were informed that the flight was cancelled, as was indicated on the airport departures board. Their luggage was returned to them, and they were then driven to a hotel, where they spent the night. The following day, the passengers were checked in at another airline's counter for a flight with the same number as that on their booking. Condor did not schedule another flight with the same number for the day concerned. The passengers were given different seats from those they had been allocated on the previous day. The booking was not converted into a booking for a flight scheduled by another airline. The flight concerned arrived in Frankfurt at around 7 on 11th July 2005, some 25 hours after its scheduled arrival time. The Sturgeons took the view that, considering all the above-mentioned circumstances, the delay of more than 25 hours, the flight had been not delayed but cancelled. The Sturgeons brought an action against Condor before this local court in Rüsselsheim in Germany, claiming compensation of €600 per person plus damages, since in their view the damage sustained was the result not of a flight delay but of a cancellation. Condor contended that the action as framed should be dismissed on the ground that the flight in question was delayed and not cancelled. Prior to the proceedings before the National Court, Condor claimed that the flight had been delayed as the result of a hurricane in the Caribbean, but during the proceedings it attributed the delay to technical faults on the plane and illness among the crew. Mr. Bach and Miss Leppershitz booked return tickets with Air France from Vienna, Austria to Mexico City, Mexico, via Paris, France. The Mexico City-Paris flight, which Mr. Bach and Miss Leppershitz were due to take, was scheduled to depart at 21:30 on 7 March 2005. When they came to check in, they were immediately informed, without the checking in taking place, that their flight was cancelled. The cancellation resulted from a change in the flight planning between Mexico City and Paris, which arose because of a technical breakdown on the aircraft due to fly from Paris to Mexico City, and on account of the need to observe the rest period prescribed by law for the crew. In order to get back earlier, Mr. Bach and Miss Leppershitz accepted Air France's offer of seats on a flight operated by Continental Airlines, which was scheduled to leave the following day, 8 March 2005, at 12:20. Their tickets were first cancelled, and then new tickets were issued to them at the Continental Airlines counter. The other passengers on the Mexico City-Paris flight, who did not take the Continental Airlines flight, left Mexico City with several additional passengers on 8 March 2005 at 19:35. That flight, whose original number was followed by the letter A, was operated in addition to the regular flights scheduled by Air France on the same day. Mr. Bach and Miss Leppershitz arrived in Vienna almost 22 hours after the scheduled arrival time. Mr. Bach and Miss Leppershitz brought an action against Air France before the district court in Vienna, claiming €600 compensation per person for cancellation of their flight based on the regulations. That court dismissed their claim on the ground that despite the evident flight delay, the regulations did not support the conclusion that there was a flight cancellation. Mr. Bach and Miss Leppershitz appealed against that decision in the commercial court in Vienna. The holding. Articles 2, 5 and 6 of Regulation 261 of the European Parliament and of the Council of 11 February 2004 establishing common rules on compensation and assistance to passengers in the event of denied boarding and of cancellation or long delay of flights, and repealing Regulation 295, must be interpreted as meaning that a flight which is delayed, irrespective of the duration of the delay, even if it is long, cannot be regarded as cancelled where the flight is operated in accordance with the air carrier's original planning. Articles 5, 6, and 7 of Regulation 261 must be interpreted as meaning that passengers whose flights are delayed may be treated for the purposes of the application of the right to compensation as passengers whose flights are cancelled, and they may thus rely on the right to compensation laid down in Article 7 of the regulation, where they suffer, on account of a flight delay, a loss of time equal to or in excess of 3 hours. That is, where they reach their final destination 3 hours or more after the arrival time originally scheduled by the air carrier. Such a delay does not, however, entitle passengers to compensation if the air carrier can prove that the long delay was caused by extraordinary circumstances, which could not have been avoided even if all reasonable measures had been taken, namely, circumstances beyond the actual control of the air carrier. Article 5 of Regulation 261 must be interpreted as meaning that a technical problem in an aircraft which leads to the cancellation or delay of a flight is not covered by the concept of extraordinary circumstances within the meaning of that provision, unless that problem stems from events which by their nature or origin are not inherent in the normal exercise of the activity of the air carrier concerned and are beyond its actual control. Let's define some key terms under Regulation 261. A flight within the meaning of Regulation 261 consists of an air transport operation performed by an air carrier which fixes its itinerary. Thus, the itinerary is an essential element of the flight as the flight is operated in accordance with the carrier's prearranged planning. Regulation 261 does not contain a definition of flight delay. That concept may, however, be clarified in light of the context in which it occurs. The court opined that it was clear from Article 6 that the community legislature adopted a notion of flight delay, which is considered only by reference to the scheduled departure time, and which implies as a consequence that after the departure time, the other elements pertaining to the flight must remain unchanged. Thus, a flight is delayed for the purpose of Article 6 if it is operated in accordance with the original planning, and its actual departure time is later than the scheduled departure time. According to Article 2, flight cancellation, unlike delay, is the result of non-operation of a flight which was previously planned. It follows that in that regard, cancelled flights and delayed flights are two quite distinct categories of flights. It cannot therefore be inferred from Regulation 261 that a flight which is delayed may be classified as a cancelled flight, merely on the ground that the delay is extended, even substantially. Consequently, a flight which is delayed, irrespective of the duration of the delay, even if it is long, cannot be regarded as cancelled where there is a departure in accordance with the original planning. Where passengers are carried on a flight whose departure time is later than the departure time originally scheduled, the flight can be classified as cancelled only if the air carrier arranges for the passengers to be carried on another flight whose original planning is different from that of the flight for which the booking was made. Thus, it is possible, as a rule, to conclude that there is a cancellation where the delayed flight for which the booking was made is rolled over onto another flight, that is to say, where the planning for the original flight is abandoned and the passengers from that flight join passengers on a flight which was also planned but independently of the flight for which the passengers so transferred had made their bookings. The term extraordinary circumstances is not defined in Article 2 or in the other provisions of that regulation. European law provides no definition, must be determined by considering their usual meaning in everyday language, while also considering the context in which they occur and the purposes of the rules of which they are part. In accordance with everyday language, the words extraordinary circumstances initially refer to circumstances which are out of the ordinary. According to the court, it was apparent that the regulation seeks to ensure a high level of protection for air passengers, regardless of whether they are denied boarding or whether their flight is cancelled or delayed, since they are all caused similar serious trouble and inconvenience connected with air transport. That is a fortiori the case since the provisions conferring rights on air passengers, including those conferring a right to compensation, must be interpreted broadly. In those circumstances, it cannot automatically be presumed that passengers whose flights are delayed do not have a right to compensation and cannot, for the purposes of recognition of such a right, be treated as passengers whose flights are cancelled.